Good evening, gentlemen. I'm sure our day was well and healthy. All right, you're welcome to tonight's online session. And tonight we are going to be looking at the topic Incorporated Trustees. Incorporated Trustees in corporate law practice. We're going to be looking at the topic Incorporated Trustees in corporate law practice. If you go to Companies and Allied Matters Act, you will notice that it is divided into three parts. We have part A that talks about companies. We have part B that talks about business name. And we have part C that talks about incorporated trustees. And our interest today is with part C to look at the concept of what an incorporated trustee is all about. Now, incorporated trustees are non-business and non-profit oriented organizations formed for the purpose of facilitating matters that are concerning religion, academics, or charitable purpose. So your take home from this definition is that an incorporated trustee does not do business. An incorporated trustee is not in the business of making profit. An incorporated trustee is into non-profit oriented activities. And on that note, we now have to look at the type of organizations that fall under incorporated trustees. The type of organizations that we can see as incorporated trustees, for instance, churches and mosques can be registered under Part C of CAMA because they are non-profit oriented. You know, that is what we are meant to believe. But a lot of churches, we know that they are into business, and a lot of mosques are also into business. Churches have schools, they make money, they pay them school fees. But they are now saying now that even schools themselves are also registered under incorporated trustees. Now, research centers can be registered as incorporated trustees. Foundations can be registered as incorporated trustees. For foundations are like NGOs. NGOs can be registered under incorporated trustee. Now, incorporated trustee can operate without registration, but it cannot enjoy the various advantages of corporate registration. So, in incorporated trustee, you can choose to operate without registering it. Now, I want you to follow me now. For companies which are Part A, they must be registered. For business name which is Part B, they must not be registered. But if they answer or pick a particular name, then that name must be registered. I hope you're following me now. For business name can only be registered in some instances. But companies must be registered in all instances. But incorporated trustees, no matter the instance, you can choose not to register it. Nobody is mandating you that you must register an incorporated trustee. That is what we are discussing now. So you must not register incorporated trustee under the CAC. You must not register it. So you can choose to carry on whatever thing you're doing without registration. But one thing now is that you are not going to have a corporate status. Corporate status now, you're not going to have the status of recognition under the law. But what if an incorporated trustee is finally registered? Is it the incorporated trustee that you are suing, or is it the incorporated trustee that has what is called distinct personality? No. When you are to sue something like a school, for instance, now the name of the school now is ABC Group of Schools or ABC Schools. If you're to sue that school and that school is ordinarily registered under CAMA, what you have to sue is the incorporated trustees of ABC Group of Schools or ABC Schools. Or you sue registered trustees of ABC School. You don't sue ABC Schools, no, because in the eyes of the law, ABC Schools is not a distinct personality. So you are now suing the registered trustees of ABC Schools. I believe that this particular one now, our lecturers will exhaustively treat it for you. So what you need to know that once it is an incorporated trustee, remember that schools can be registered as incorporated trustees. So once it is school or any type, even if it's a church, it has to be the incorporated trustees of the name of that church. You have incorporated trustees of Cherubim and Seraphim, plaintiff. You now have the other person as what? Defendant. That is what we're talking about here. So, but note that you must not necessarily register incorporated trustees if you don't want, no matter the name that you choose for yourself. Now, what are the features of incorporated trustee? What are the characteristics of what makes an incorporated trustee to be an incorporated trustee? One is that the trustees are the only persons who obtain separate legal personality, not all the members. I said it before. So that is why you have the incorporated trustees of. So it is only the trustees that have the distinct legal personality. It is not that particular organization itself. It is the trustees. Also, it does not do business and does not distribute its profit. So IT, remember we said that it is non-business organization. So it does not do any type of business at all. And any profit that it makes, in the event that it is about to die, is about to be dissolved, that profit that they make or whatever thing they have as their profit cannot be shared among themselves. That is the members. They cannot share it among themselves. The only thing they have to do is that they will have to distribute it to another organization that is into the same type of activity. But if they don't have any type of organization like that, they will give it to charity. If they cannot, they will now give it to the office of the Attorney General of the Federation. Now, its income is generated through grants, levies, and dues. So the only way they generate money is by maybe levying the members to be paying a particular levy or to be paying dues. One thing different about levy and dues is that dues are paid in a routine basis. Dues can be monthly, dues can be yearly, but levy is at intervals. Levy can just come up anytime. Maybe there is something they want to do, they can levy people to pay. So that is one thing about the difference between dues and levy. And the income must be applied only to the reason why it is established. So for instance, if it is into research, remember we said that research centers can also be registered as IT, that incorporated trustee. So if it gets any income, it is going to apply that income only for the purpose of why it was registered, of why it was established. That's what we're talking about here. Now it can also own properties. So incorporated trustee can also own properties, and it may be dissolved by the Federal High Court. So for incorporated trustee, it is called dissolution, not winding up. Winding up is for companies, but for incorporated trustee, what you call it is dissolution. They are dissolved. So the Federal High Court can also dissolve it. Now, if you notice now, if you're very, very canny, you will notice when you were listening to my voice notes on companies, you will notice that there is a type of company known as company limited by guarantee. And the company limited by guarantee seems to have some sort of peculiarities with this IT, because company limited by guarantee too, they don't share their profit. Company limited by guarantee too, they are also, maybe schools can also be registered as company limited by guarantee. Churches can also be registered as company limited. Research centers can also be registered as company limited by guarantee. So, what then is the similarity between a company limited by guarantee and an incorporated trustee? One is that they are governed by the provisions of CAMA. Both of them are regulated by CAMA because you can register them under CAMA. Also, they are not established for profit making. So they are not established to make profit. So both incorporated trustee and company limited by guarantee are not into the business of making profit. Also, they are exempted from payment of, please, what I'm outlining now is an exam area. I want you to take it serious. They are also exempted from payment of tax. So company limited by guarantee and IT, they don't pay tax. So they are exempted from paying tax. Also, they are regulated by CAC. It is CAC that regulate them. That is Corporate Affairs Commission. And they have the provision for special clauses. They have provision for special. What is a special clause? A special clause is a clause that is contained in either the Constitution or the Memorandum of Association, because in company limited by guarantee, they use Memorandum of Association. But for IT, what IT use is Constitution. Company limited by guarantee use Memorandum of Association. IT uses Constitution. So now, company limited by guarantee also has Article of Association. So Article of Association plays the role of Constitution for companies limited by guarantee. So that the Article of Association now, they are going to have what is called special clause. And also, in the constitution of an IT, they will also have what they call special clause. What is special clause? Special clause is a clause containing the information that in the event that this particular organization is folding, that their profit is not, sorry, that their property is not going to be shared among the members. Instead, that it is going to be given back to another organization that is into the same purpose, or it will be given back to charity, or it will be given to the attorney general of the federation. So one thing you need to take home here now is that the properties or the profits that accrues to an IT and the profit accruing to a company limited by guarantee are not being shared among the members. The members don't share it. Unlike a company where members will share profit and go their way, it is called declaration of dividend. So members will share profit and be making money every year and be going their way. Such is not obtained in an IT or company limited by guarantee. Now let us look at the difference between incorporated trustee and company limited by guarantee. We have talked about their similarity. Now let us look at their peculiar differences. Now in company limited by guarantee, there is a requirement for the consent of the Attorney General of the Federation before it can be registered. But in IT, such a requirement is not there. You don't require the consent of the Attorney General of the Federation to register an IT, but require the consent of the Attorney General of the Federation to register a company limited by guarantee. Now, IT uses constitution, while company limited by guarantee uses memorandum and articles of association. IT uses constitution, while company limited by guarantee uses memorandum and articles of association. Now, the next difference is that IT has board of trustees, while company limited by guarantee has board of directors. Remember that company limited by guarantee is a company, so what they have is board of directors, but incorporated trustee has only what is known as board of trustees. Also, company limited by guarantee must be registered, while registration of IT is optional. Remember I said that all companies must be registered. So, and I now told you now that IT, you can choose to register, you can choose not to register. So registration of a company limited by guarantee is mandatory, but registration of an IT is optional. Also, company limited by guarantee can do little business. Company limited by guarantee can do little business because it's a company. It can do little business. The only thing is that they don't share their profits. But IT cannot do business at all. IT cannot do business at all. That is one thing you need to take home there. IT cannot do business at all. All right, let us look at appointment of someone as a trustee. Who can be appointed as a trustee? Now, we are going to tell you about who cannot be appointed as a trustee. From knowing who cannot be appointed as a trustee, then you now know who can be appointed as a trustee. Now, the following persons cannot be a trustee of a company. The following persons cannot be a trustee, meaning the following persons cannot be members of the board of trustees of an IT. They cannot be members of board of trustees of an incorporated trustee. One is a minor. A minor, remember I told you, somebody that has not attained the age of 18. He cannot be a member of the board of trustees of an incorporated trustee. Also, persons of unsound mind cannot also be members of board of trustees. A bankrupt person cannot also be a trustee. A convict cannot also be a trustee. A convict includes both a person that has been an ex-convict, they cannot be a trustee, and the persons who are not domiciled in Nigeria, people who are not living in Nigeria, cannot be members of the board of trustees. What we mean here is a person who is presumably not a Nigerian. Not that you are a Nigerian and probably you can choose to go on vacation and come back. Such does not fall under this category. So a Nigerian cannot be a member of a non-Nigerian cannot be a member of board of trustees. Now let us look at the documents required to register an IT. The documents required to register an IT, checklist of the documents required to register an IT. One is the constitution of the organization. So the organization must present their constitution before they can register as an IT. Remember, I told you that registration as an IT is optional. But when you finally choose to register it, these are the documents that you must present to CAC before you'll be allowed to register. We said that one is constitution of the IT. The next is evidence of availability of landed property or undertaking in lieu. What we are talking about now is that the IT must show that they have a landed property, or they will give an undertaking that they will be getting a landed property very soon. That is what we mean by that. And so you must show an evidence that you have bought a land, or you have bought a property in Nigeria, or you must guarantee that in days to come you will be buying a property. Also, there has to be publication in one national daily and one local daily for objections from members of the public. So you must publish in one national newspaper. National newspaper are just like Daily Sun. They are national, meaning that they are covered in every part of the federation. And another local daily are those that are in circulation in that particular locality. So you must show an evidence that you have published this your intention to be registered as an IT, so that if members of the public wish to object to you being registered as an IT, or maybe there is any dent on your image, so people can easily object by having been notified that this person is planning to have an organization. Also, the address of the organization, you must also give an evidence of where this organization is situated. So there has to be an address notifying the people. Then you also have CAC IT Form 1. CAC IT Form 1 is the application form. So you must it has to be one of the documents that are required before you register. So you must get the CAC IT Form 1 and fill it, so that you will be submitting it alongside these documents that we have been talking about. Also, 2 passport photographs of each of the trustees. 2 passport photographs of each of the people that will be trustees of that organization will also be presented. And also minutes of the meeting where the trustees were appointed will also be contained in these documents that we are talking about. All right, another exam area are the clauses to be included in the constitution of an IT. The things that have to be included in the constitution of an IT. There are many, but I'm going to be giving you the major ones. The major things that have to be included in the constitution. Remember, we said that IT uses constitution, while company limited by guarantee uses memorandum and articles of association. So we want to now look at the contents of the constitution of an IT. And I said that there are many, depending on whatever be the intention or the reason for which the IT is established. But we are not going to be looking at the major clauses, no matter what the intent or what the activities that the IT is being established for is. So we are going to be looking at the major ones. Now, one of the things that will be contained in that particular constitution of an IT is one name. The name of the IT will be contained. The aims and objective will be contained. The common seal will also be contained. The special clause, I told you what special clause means, is a clause that they are going to expressly state that the profit of the company is so the profit of the organization is not expected to be shared among the members in the event of dissolution, that it is going to be reinvented back to the society by giving it to another organization that is into identical type of activity or into a charity purpose, or even to the office of the Attorney General where none of these people were gotten. Also, the mode of appointment, the mode of appointing trustees will also be contained in the constitution. The governing board, the number of persons that will be in the governing board, and also how the governing board will be having their meetings, and also how to remove somebody from the governing board, all this will be contained. The meetings of the organization will also be contained in the constitution, how many times in a year they will be having their meeting, and also what will be the quorum. Also, accounts, how accounts will be rendered and at when will the account be rendered will also be contained in the constitution. Now, contribution and fund. So how they are going to be raising their money, is it by levy, is it by dues, or is it by 2 of them? Such will also be contained. And also auditing, how will the funds of the particular of this IT organization be audited? So how will we see the transparency that are expected to be obtained in the activities of the trustees? So we are going to contain is, are we to appoint an external auditor to come and do this, or are we to have a standby internal auditor? So all these are going to be contained. And also the disbursement of the fund. How will funds be disbursed? What are they going to be used for? How many percent are we to be giving out for the very first time, so that when there is progress in what we have disbursed the fund for, then we can give the remaining percentage. So all these things have to be expressly stated in the constitution, which is like the Bible of the incorporated trustee, because it is what will modulate and regulate the activities of the trustees and also other members of the organization. On that, we are going to be drawing the curtain on the topic incorporated trustees. And remember, we are always regulated by law school outcomes and law school expectations. If you listen to this voice note very well and make your side notes from it, if you get any question on IT, 90% of the time is not going to be outside the purview of what we have thus captured in this particular voice note. Until I meet you again, do take good care of yourselves and have quite a blissful night rest.